All right, are you ready?
Oh, yeah.
You are? Great. We're going to find out. We're going to do all that.
Yeah.
Okay. All right, let's go on the record. This is 24 CV 002805, Judicial Watch versus the District Attorney of Fulton County in her official capacity. If we could please, for the record, have counsel for Judicial Watch introduce himself.
John Monroe for the plaintiff, Your Honor. Also here with me is in-house counsel Russell Mobile.
How do you spell your last name?
Nobile.
Like Mobile, but with an N.
Correct, Your Honor.
Got it. Okay. And on behalf of the District Attorney's Office.
Yes, good morning. Sandy Monroe, and on behalf of the District Attorney and the District Attorney's Office.
It's a lot of Monroes.
Yes.
Oh, you couldn't see her. Oh, you're like, hey, how are you starting this? Yeah, no, I promised to hear from both sides, and we have a Monroe for both sides, so we should be good to go. So let me set the table. My understanding of where we are procedurally is that if we go way back in time, Judicial Watch filed an Open Records Act request with the District Attorney's Office. They were informed there were no responsive records. The request was, in general, I'm not going to get it exactly right, please share all communications with Jack Smith in connection with his work on the January 6th investigation and any of his employees, as well as any communications between the District Attorney's Office and the committee or commission that was investigating the January 6th situation. That was more or less the request. More relevant to what we're working through today, the response, whether it was from the District Attorney's Office or through the County Attorney, I'm going to refer from the District Attorney. It may have come through the County Attorney's Office, but the response was, we don't have anything. Mr. Monroe and perhaps Mr. Nobile were surprised by that answer. Ultimately, they brought the lawsuit that is before me, seeking to compel compliance with the Open Records Act and for the disgorgement of responsive records. There were some interesting administrative hiccups in the way the case proceeded that culminated in a ruling that the District Attorney was in default. Not purposefully so, but that's how it played out, and that hasn't been challenged yet. So the current posture is that the District Attorney is in default. The default order gave the District Attorney's Office a pretty tight time frame in which to do what it had been asked to do by Judicial Watch originally through the Open Records Act request, which was to produce these documents. And one document was produced. I believe it was something that actually Mr. Monroe had provided the District Attorney's Office, saying, here's a reason why we think there might be some things. And that was handed back. And as well, there was a response that said, well, and these aren't the exact words, but either we looked for the first time or we looked again, and there are some things, but you can't have them because they are privileged or for whatever reason, they are not under the terms of the ORA properly disclosable. And so here we are. Mr. Monroe is seeking on behalf of Judicial Watch two things. Only one is ripe for discussion, and that's the attorney's fees. There is also a pending motion to have a special master appointed to clear up some of the mystery around how could the first answer be we have nothing, and then the second answer is we have something but you can't have it. I understand the basis for the request. Ms. Monroe, on behalf of the District Attorney, I don't expect you to be ready to respond to that. We may kick it around a little bit, but it's not yet right. But since we're all together, I'll want to at least get an initial perspective on behalf of the county as to how we might navigate that. But what I think is properly before me is the request for attorney's fees. And I'm going to hand it over to Mr. Monroe to go forward with that. But before I do, anything else you want to get into the record about where we are procedurally or anything you want to correct me on so I'm not laboring under a misapprehension of what's going on?
I think everything you said is correct, Your Honor, but I would slip one more data point kind of in the middle of that. And that is after the litigation started, but before the default order, We did some written discovery, and the district attorney's office said in response to interrogatories that they've looked again, and there still are not any records, neither non-exempt or exempt, no records at all.
Okay, so there were two responses of we have nothing, and now we have something,
That's right,
but you can't have it.
correct.
Okay, got it. Thank you for clearing that up. Now that I'm remembering reading, I think this was in your motion or petition for a special master. There were three responses that had been received. I omitted referencing that second one.
That's right.
Ms. Monroe, I want to give you the same opportunity to say, well, Judge, you got it partly right. And I'm not making any rulings in sharing this. I just want to streamline this morning so that we don't need to cover things if I'm correctly understanding where we are.
You have it absolutely correct, and with that addition, I do agree with the addition made by Ms. Monroe. Also too, I would like to inform the court that since the court's ruling, the county on behalf of the district attorney's office have made zealous efforts in trying to settle this matter in hopes to forego and pull out a hearing on attorney's fees. Given the nature of the matter, the new information that has developed over the course of the last month or so by way of the deposition and by way of the court's order, it is the district attorney's position that we settle this matter in efforts to preserve the resources of the court and the times of the parties. We don't want to undergo or continue unnecessary litigation. We've told the other side this. We've been waiting to hear back to see what that would look like. They did provide documents in support of their claim for attorney's fees. I would like to have that discussion. We have not had that opportunity to do so. And so what I would put before the court is an offer to have that discussion to avoid unnecessary litigation here and to see how we can get this matter resolved.
Okay, is part of your view of settlement, I understand what you're saying. It's funny because that word doesn't quite fit the nature of it. It's not, hey, Mr. Monroe's client was injured in a bus accident. You're representing MARTA, and how do we make you whole? But certainly it would be great if there's a way that Mr. Monroe could reach a point where he said, we're satisfied that we've got what we've got. We're not getting what we're not getting. And whatever the financial issues are resolved as well. And if I don't need to get in the middle of that, it's probably better for everyone. But I'm here to get in the middle of that, and or a special master is, when you are thinking about this concept of settlement, does it include addressing the concerns Mr. Monroe raises in his motion for the in-camera inspection and appointment of special master? And it's listed as an and. In theory, it could be an or, depending on the volume of the documents. I could always be the one who reviews them, but if we're getting into like 4-digit page numbers, then a special master is probably the right one to have the amount of time available to do that. But I don't want to get into the mechanics of that so much as, I guess where I'm probing a little bit is, you're also thinking about addressing the concerns Mr. Monroe has raised about, well, you say there are these things that we can't have, but there's not even a privilege log, which is what I'd be accustomed to seeing, that there's a description of what the document is, an email to Jack Smith or an email to Representative so-and-so, but the contents relate to ongoing litigation or an open criminal matter that the district attorney's office is pursuing. It doesn't sound like that's what was provided. It was just there's a box and you can't see in it. So talk to me a little bit about what you envision. Again, you're not binding yourself to anything, but what does settlement mean? Not on the $20,000 is a whole lot for attorney's fees. Maybe we could do less than that. What about the document side?
So that's a good question. I thank you, Your Honor, for proposing that. So that's the type of conversation that I was hoping to have with opposing counsel substantively as to how to get this matter resolved on a global scale. We're not interested in a piecemeal settlement, obviously. The attorney's fees would continue to accrue even if the court were to entertain their motion for in-camera review or assignment of a special master. if we're gonna resolve this case, it would have to include documentation. Now, in terms of what that would look like, I understand that plaintiff and plaintiff counsel is not satisfied with our representation, so we would have to certainly.
Satisfied with your representation, meaning like you shouldn't be representing?
No, sorry, not my representation personally, but
Okay.
our representation of the materials, of the
Got it.
responsive records in question. And so that's something that we would have to go back with our client to sit down with those records, right? And see if we could come up with a plan that would provide some sort of, lack of a better word, piece in terms of what these documents are, why they're being withheld,
Sure.
and how we can eventually close out this matter.
So this would be short of having a special master get in the mix or having me get in the mix?
Correct.
Okay, got it.
Again, the goal is to keep costs down and to preserve the, the court's resources and the resources of the parties.
Okay, I appreciate your focus on preserving my resources. I, of course, am also focused on timeliness. And by that, I don't mean you've been slow, but this case was filed a while ago. Judicial Watch has been waiting for a while. And so I want to just strike the right balance between what would get things done quickly versus what would get things done efficiently. Mr. Monroe, I don't know to what extent you and Ms. Monroe have connected on this front. She sounds sincere and motivated to have a conversation about sorting things out lawyer to lawyer rather than pulling the court in or bringing a special master in. Tell me your thoughts about that.
Well, we're certainly, not opposed to trying to resolve a case, Your Honor. We've discussed it somewhat. The problem we have is we don't know what we don't know. They've said we've got some stuff, but you can't see it. So I guess all we know to do, the only tool in our toolbox is, well, I guess it's two-pronged one, the in-camera inspection and the special master.
Sure.
We know that, like for example, Mr. Bond said at his deposition that when their first response of we don't have any records, he admitted in his deposition we never searched.
Right.
And then the second time, after the case was filed, they said we don't have any records, not even privileged records. And now they're saying, well, we do have some records, but they're privileged. So we don't have a lot of confidence in whatever it is they're doing when they say they're searching. And so since we don't know what's there, it's hard for us to come up with any kind of proposal short of what we've asked the court to do in terms of trying to remedy this.
Right.
And I don't know, for example, that we could even come up with an agreement on attorney's fees because we don't know what's going to happen going forward. For example, if the court appointed a special master, there might be meetings with the special master, there might be more hearings. There could be a lot more work involved. So at this point, it's hard for us to say we'd settle for this because, as you point out, it's not a bus accident. We can't just say this is how much money we need and we'll be happy and we'll go away.
Right. And I don't want anyone to go away, but I do want people to get what they've asked for. So tell me your thoughts, Mr. Monroe, and you may need to confer with Mr. Nobile, and I'll give you a chance to do that. If what we did was to briefly, and by that I mean a matter of weeks, not months, although I'm mindful that today is the last day of business for lots of people for a few weeks. But if we briefly tap the brakes on sorting out attorney's fees, and it's not ripe yet anyway, but ruling on the special master request so that you could, at a minimum, have a discussion with Ms. Monroe to get a sense of what it is they have in mind. And if it's not satisfactory, or you try it out. And it may be that one of the first things that happens is that Ms. Monroe and her legal team say, of course we have to do a privilege log. We can't just say you can't see it. Because I'm not 100% convinced that Ms. Monroe is the generating the flow of communications that get to you. And so she might be able to dig in a bit and say, here's a privilege log, which would give you a better sense of, all right, I see why I want the judge to look at these 10 documents. But I can tell that just based on this log, there's got to be more. I mean, because you've seen nothing, it's hard to know how comprehensive the universe of documents that are alleged to have been found is. And you're certainly entitled, or someone on your behalf, a special master or me, entitled to look into that to say, well, how is there's like a 3-week gap. We have up through July, and then there's not another communication until September. What happened in August? That kind of thing. So I'm wondering if you would be open to having an exchange or two with Ms. Monroe to see where that gets everyone. It doesn't stop the attorney fee meter. It just might have it run a little more slowly than if we went whole hog into a special master, which I'm not opposed to. I like a graduated approach. And I'm hearing Ms. Monroe say, well, couldn't the next step be we have some serious discussions? Not that you've ever not been serious about it, but maybe you haven't had a meaningful dance partner on the other side about getting greater visibility into what is being withheld, and to your other point, a description of what was searched and what wasn't.
I guess I'd say, first of all, of course, I'd like to discuss it with Mr. Mobile, but I'd point out that in addition to now they're saying there's some stuff we've got, but you can't see it, we have serious concerns about how they go about their searches.
No, I understand that. That's what I meant about the part 2, which would be, it may be that Ms. Monroe would be in a position to share with you what she knows. I mean, I guess you know some because of the deposition, but I don't know what my role or special master's role would be in learning a whole lot more about that.
Well, what I envisioned when I filed the motion asking for appointment of a special master is basically to have a third party come in and essentially start from scratch, because based on what they've given us and what they've said and Mr. Bond's deposition, it sounds like their methodology for doing searches is very ad hoc and haphazard. So even if they gave us a privilege log, for example, that had a list of pinned documents on it, for all I know, there's 1,000 more that ought to be on that, either produced or be on the log.
Yep.
And I think the only way we're going to get to some level of confidence that a real search has been done is to have a third party either do the search or monitor the search.
Okay.
So I don't, unless something changes, with what I know today, I don't see a way around having a special master involved.
Okay. I understand that, and you may well be right. Because it's not yet right, it seems like there will be an opportunity for you and Ms. Monroe to have a discussion. I know you will be out of pocket. Lucky you, Ms. Monroe. So I'm starting, today's your last day for a few weeks.
You know, kids are out of school, so.
Oh, hey, amen, same. That could start today for me, for one kid. But you're back in action that first full week in January. By then, I think the special master motion will be ripe anyway. And so it will be, well, no, that won't be till mid-January. So you'll have some time to talk before you would need it to have responded to the motion for the in-camera inspection. So why don't we, since we have everyone here, at least make a record of the attorney's fees that have been accumulated to date, whatever records you want to make, and Ms. Monroe will have an opportunity to highlight what she wants in connection with that. And then we will, at least that'll be locked in. And I don't need to rule on it yet, other than that we've made a record. And then I'll encourage the Monroes to take advantage of those first couple of weeks in January to talk about what might be done. And there may be some work that the county does that can be shared with Mr. Monroe that begins to generate some confidence that there was a search that was somewhat thorough, but I fully understand, Mr. Monroe, your sentiment that there hasn't been real wholehearted, full-throated effort to dredge up what ought to be disclosed, or at least identified as responsive but not disclosable under the ORA. So I don't want you to take from this conversation that I'm pushing back on the notion of a special master. It might get pretty contentious and complicated if the special master is implemented sort of at the DEFCON 1 that you're suggesting, which is he or she does the search, because that's sort of in someone's backyard. But there are some intermediate steps where getting someone to interact with and look at, this is what you said you searched, and who has full access to that which was identified but not produced, where then the special master could come back and report to you and to me and to Ms. Monroe about his or her findings about the thoroughness. But we'll work through it. All right. Then why don't we go forward with what you wanted to talk about on the attorney's fees side. Before we do that, I'm presiding today as well, and I want to get Ms. Laster on her way. Which one of you is Ms. Laster? Hi, Ms. Laster. I've looked this over and I signed the affidavit approving it, okay?
Thank you.
You bet. Good luck. Have a good holiday. Before you start though, maybe it's just, this was one of the filing issues, the motion for attorney's fees. You sent me a hard copy. Can you find it in the?
We didn't actually file a motion for attorney's fees, Your Honor. I mean,
Why are we here?
we requested attorney's fees as one of our items of relief. In your order of default, you said, okay, they're in default. Now we need to have a hearing on attorney's fees.
Got it. Okay, good. I just was looking for the hook. I knew we were properly here for that. I just wasn't sure which of your pleadings got us there. So it's your motion for default judgment?
Yes, and then after you entered the default, we did file documentation information on fees and affidavit and stuff like that.
Just
but we didn't actually file a separate standalone motion for fees. We would have, if you would have just entered a default, we would have done that, but you took care of that because in your order, you set it down for a hearing on attorney's fees.
Okay, let me get your. Okay, I'm ready.
All right. So under OCGA 50-1873B, if the court finds that a party lacks substantial justification in an Open Records Act case, the court shall assess reasonable attorney's fees and other litigation costs. The Court of Appeals ruled in Benefit Support Inc. versus Hall County. That's at 281 Georgia App 825 2006 case. And I do have a copy of the printed out if you want it, Your Honor.
With the citation, I'm good to go.
Okay. In that case, the court established a two-pronged test. First, the plaintiff must show that the defendant violated the Open Records Act. And then second, the plaintiff must introduce some evidence that the defendant lacked substantial justification. The first prong is already taken care of because you ruled in the default order that the district attorney's office violated the Open Records Act. To quote your order, you said the court has, in effect, declared that she violated the ORA. So the only question today is if DA Willis lacked substantial justification. Referring to some of the items in the record, the response to the request was met. Well, first of all, there was the next day after the request was filed, there was a request for clarification or paring down of the open records request. And then when you work with the portal, I don't know if you're familiar with it, but there's a portal for all of Fulton County operations.
So you were on the county side, because I know the only reason why I'm asking is that I was a little surprised. One of the documents that's been generated here, the district attorney's office seems to have its own open records unit or person. And so I was curious if you were able to tell from your initial I guess the first thing you received was could you clarify or narrow your request? Ultimately, you received we don't have anything.
Right.
That all came through the portal and not through anything directly from the DA's office or Mr. Bond or anything like that?
So it's a little complicated. If you go on the DA's website, there's a link you can click on for open records requests. That link takes you to the county portal.
Okay.
Or you can go to the county portal, but you end up in the same place either way.
Okay.
So you put in a request, and the request itself identifies that you're looking for DA records. I don't know exactly what happens downstream, but it somehow, if it's a DA request, gets sent over to people that work for Mr. Bond that he identified in his deposition.
Meaning you would go through the county portal saying, I want to know how many murder cases the district attorney's office pled out in 2023. And if that's a valid request, the county, as best you understood it, the county portal people would have to push that across to the DA's office saying, this is the kind of information we do need to provide. You need to gather it.
That's right.
Okay.
And then it's not apparent to the user, the person who makes the request, who generates a response. It appears to come from the county.
Okay.
But I've learned based on other cases and during the deposition of Mr. Bond that that if the responses are DA's office related, they're probably actually being generated by someone in the DA's office, but they come through the portal back to the originator of the request. So you can't tell who's answering because they're not signed or anything.
Okay.
So anyway, originally there was just an acknowledgement receiving the request. And then the next day there was can you please clarify it? And then 5 minutes later, before there was an opportunity to do any clarification, it was, we don't have any responsive records.
You had not yet clarified or narrowed your request. You received a request to do that. And before you did anything came number 3, which was, we have nothing.
That's right, and I don't even know, I'd have to, Mr. Nomile may not even know, I'm not sure Judicial Watch even had seen the request for clarification before the, we don't have any records came.
Okay, so you received an acknowledgement, thank you for making a request.
Mm-hmm.
Next day, could you clarify or narrow it? And before really someone could take a breath, then we don't have it.
That's right. And then Mr. Bond admitted, confessed, whatever during his deposition that in fact no search was done before that response of we don't have any records was created. That's in his deposition transcript on page 76, line 7. Because we had the one letter that we attached to the complaint, then we knew that that can't be correct. There must be some responsive records. So we filed the complaint. And then after the complaint was filed, Mr. Bond said that he searched again, and he said in his deposition that that was largely by asking people if the office had any records. That's in his deposition, page 53, line 15. And then during his deposition, despite repeated questions, trying to get at it from many different angles, Mr. Bond was not able to give a comprehensive description of what search was done and how it was done or anything like that. And then even after the court's order, the response that came in, which we filed into the record, it was undated, it was unsigned, it was just on DA letterhead. There was no privilege log, as you pointed out. And there's not actually even an affirmative response saying, we have some stuff, but you can't have it. It just said that stuff would be privileged. So we still aren't sure if they actually did a search and have, identified any records that are responsive, because what they said was, oh, well, that would be privileged. And here's the privileges that would apply. But
how did you know to depose Mr. Bond as opposed to someone else? It was sort of a 30B6-ish thing. Who do we talk to, county, to know, or his name had bubbled up?
Well, what happened was we sent 2 batches of interrogatories, and they came back. Both of them came back unverified. And so I contacted Ms. Monroe and I said, "Who's signing these?" And then she ultimately gave me a verification signed by Mr. Bond for both sets of interrogatories. Okay. So I thought, well, if he's the guy who knows all this, that's the guy I'll depose.
Start with him. Okay.
Yeah. So then they started by not doing a search at all, even though they said they did. And then they apparently didn't really conduct a meaningful search. And then at least their third opportunity, they gave us an undated, unsigned, unprivileged log saying that if they had records, they'd be privileged. That certainly lacks substantial justification, Your Honor. That's not how open records requests are supposed to be dealt with by a government agency. I can go into numbers now if you want, or do you want to hear from Ms. Monroe on that issue first?
Whole presentation, and then whatever Ms. Monroe wants to add. It sounds like there's not a lot of disagreement about what the timeline is and what the events are that make up that timeline. She may want to argue that it was justified or whatnot, but I'll hear from you about everything, and then Ms. Monroe.
Okay, so I filed an affidavit in the case with all this information I'm getting ready to tell you, but I'll stand in my place and say my hourly rate is $400. It's reasonable in the area for someone with my level of experience and skill. I've been practicing law for over 30 years, largely devoted to civil and criminal litigation. Of course, criminal cases are largely done on a flat rate, but when I do civil cases at an hourly basis, I charge $400 an hour. I collect $400 an hour. It's not a pie in the sky, oh, this is what I wish I would get. That's what I actually charge and collect.
Judicial Watch is paying you $400 an hour.
Judicial Watch is paying me $400 an hour, and except for the things in the past probably week or two, they have paid me for everything that I've requested here. If you look at the affidavit, I've spent 51.7 hours on the case. I think the time I've spent on it was reasonable.
Yeah, so I do have your affidavit, and it talks about how much you have to drive to get here because you live far away. Oh, there it is. I hadn't seen the first sentence. You actually have Exhibit 1 breaks out the hours. So
yes,
keep going.
Yep,
that's what I've been looking for.
Okay,
I missed it.
All right. So that equates to $20,680 for fees. For costs, there was a filing fee of $252.84. There was a service of process of $90. Mileage for the deposition was $87.10. Parking for the deposition was $20.
Where was the deposition?
It was across the street in the county attorney's office. Okay. The transcript of the deposition was $1,661.20. Another $87.10 for mileage for today's hearing. Another parking fee of $20.
Where do you park that costs $20?
That's how much the underground charges.
Really?
Yeah. I mean, I don't know of another place to park.
No, I didn't know it cost that much.
Yeah, and in fact, you can see on the court reporter's bill that I included in there, she also paid $20 for parking.
She should be charged the same.
Yeah, that's how much it costs to come down and
who knew?
And petition our government for redress of grievances.
Small price to pay.
Yeah. So the total costs are $2,218.24, which makes a total fee and cost a number of $22,898.24. I do have some additional documentation of the reasonableness of my fee if you want to see that. Or if you're satisfied with it, I don't want to burden the court by.
No, we'll let Ms. Monroe have her crack at it, but based on my experience, which is less than yours, but often brings me into contact with lawyers who are citing the reasonableness of their fees. You fall healthily within the heartland of an hourly rate for someone with your experience, relevant experience. So I don't have an issue with that thus far.
Okay, I'll just, without actually going through all the paperwork, I'll tell you that earlier this year,
some court in Wisconsin.
Well, actually, that was last year.
Okay, that wasn't as compelling. Who knows what they pay lawyers in Wisconsin?
Less, but because I'm licensed there too. But I will tell you that earlier this year, the Superior Court of Rockdale County found my rate of $400 to be reasonable in a case that involved a fee shifting statute.
Okay.
And I have that order here if you want to see that. That's all I have, Your Honor.
All right. And would you like, I guess it's in the record because it's attached to your affidavit. So we don't need to tender it here. It's something that's available to everyone.
Yeah, I don't think so.
Okay.
Thank you.
All right. Thank you. So Ms. Monroe, we don't need to talk about the value of settlement discussions. You can still have those, and I share your view on that. Today, we're just going to focus on fees and whether they are properly awardable, and if the figures that Mr. Monroe just shared are in fact reasonable. And I'll tell you, just so you can focus your time, I'm not struggling too much with the reasonableness part. That's a pretty reasonable hourly amount, and having finally found the breakdown of the hours, that seems pretty reasonable as well. I don't mean to preclude you from talking about that. I'm more interested though in your view of the lack justification, because of course it doesn't matter if he billed $1 million an hour. If his client isn't eligible for the fee award under 1873B, then we don't need to worry about it.
So thank you so much for outlining that. So in terms of the substantial justification, I've heard plaintiffs' counsel repeat over and over their confidence in the DA's office ability to, or diligent searches that have taken place. And the letter that was provided to his office pursuant to the court's direction and instruction to provide documents within 5 days of the default order, it specifically states that a diligent search was conducted. And as a result of that diligent search, there are documents, however, they're subject to an exemption. So in terms of their confidence in the actual search, there's nothing that has been brought forth by plaintiffs' counsel to suggest that there is an error in which they went about searching for these documents. Now, I can't speak to how the search was handled at the time of the request, nor can I speak to how the search was handled at the time the two separate discovery requests were provided. I do understand that Mr. Dexabot testified thoroughly as to what he understood the process to be. Just to backtrack a little bit of how open records portal is managed. Fulton County does foster a full open records portal for its agencies and state elected officials of the like of the district attorney's office. When a requester does go to that site, they have the ability to designate an agency in which they are seeking records from. It doesn't pretty much, just because you're using the Fulton County portal doesn't put Fulton County on the hook for every single request that is submitted through the portal, and the lack or response thereof doesn't make them liable or not liable. Plaintiff's counsel, Mr. Monroe.
Let me explore that a little bit. So if I went to the portal and said, I want all the Atlanta Police Department police reports for arrests in Zone 5. Mm-hmm. I agree with you. I don't know how that would put the county on the hook for anything, because you're using the wrong portal. You might think that's where I go because Atlanta is in Fulton County mostly. But if I go to the Fulton County Open Records Act portal, better yet, I go to the district attorney's office's website and click on open records, and that gets me over there. And I say, I would like to get from the district attorney's office X. That's a county agency. Yes, it's an elected official, but it's a county agency. Why does that request not trigger potential liability for the county? If it's not a valid request and it gets responded to on time, there's no liability. But if it's a valid request and some actor for the county, here it sounds like it would be someone in the district attorney's office, just don't do a search, because Mr. Bond has testified, we didn't do a search. How does that not, I understand the county attorney's office may have done everything it was supposed to do, and the lawyer or lawyers who man or staff the Open Records Act portal did everything they were supposed to, but another organ of the county, the records suggest to me, didn't, and so the county's liable. Now, whether it's the district attorney's office and it comes out of their budget if I award fees, or it comes out of the county's general fund, I guess I'm not following your line that, hey, just because someone used the portal doesn't mean we're liable.
Right.
Yes, but if it's my Atlanta police example, you're not liable. But let's use not an example, let's use this case.
Yes, this case, in fact. So you have state elected official, the DA herself, has her own designated custodian of records. In this case, at the time, it was Dexter Bond. That is publicized for the public to know. The Fulton County has their separate custodian of records. So although we're using the portal
Mhm.
as a means to centralize and streamline, will make it convenient for requesters and the public to make a request.
Yep.
There is a mechanism set in place to designate the request to the particular departments and agencies so that the request is received. And when it's received by that agency, in this case, the district attorney's office, and thus puts them on notice on that request. You got to remember, we have a short time frame, 3 days.
Very
So
short.
if we don't have notice of the request, how can we then be notified to actually look for the records and provide the records? Fulton County, just by way of the portal, doesn't give them notice of a request. Once you designate an agency, they then have notice of that record, and that's what happened here.
Okay,
The DA's office was designated as an agency, and that's where the request was submitted.
okay.
And all the responses were from the DA's office. It wasn't ambiguous. There's no, it's not like the responses are coming from Fulton County, although there is a general automated response that does label you'll see Fulton County as one of the headers. We have since modified that to make it more understandable to the public and to the requester that this is just a automatic generated response, but that the respective agencies will be in contact with you regarding your request. And
When you say you
responses.
since modified it, that would have been after this situation?
I don't know exactly for sure, but we do know that this has been a reoccurring issue in terms of who exactly is in receipt of these open record requests.
So in the record, attached to the complaint is the initial email, I think it's the initial one. And both will correct me if I'm wrong. Someone named Patrick Franciscon, Francescon, had emailed the portal, and there was a response to him that says, "Thank you for submitting an open records request to Fulton County, Georgia." And it signs a reference number, what they've requested, and does say, "We will send the request to the appropriate department." But there's no mention of the district attorney's office in here. So
Right.
if I'm Mr. Franciscan, who's our member of the community, who is looking for these things, all he knows is that the county is working on this.
Right.
Okay.
That's understandable. And then there is follow-up, subsequent correspondence between the actual agency and the requester to kind of clear that up. So in this instance, that's what happened here. We had the DA's office who then sent that follow-up request saying, "Hey, please clarify your request." And then that subsequent correspondence saying that we have no responsive records,
So
all
you-
of which came from the DA's office.
Okay, and I'm not doubting you at all, but if I am Mr. Franciscan, am I pronouncing that name correctly?
Yep.
If I'm Mr. Franciscan, I got an email on August 22nd of 2023. That was the generic, "We got your request, here's what you asked for. We, the county, are routing it to the appropriate department." 1 day later, almost to the hour, I, Mr. Franciscan, received an email, not from the DA's office, from Kay Burwell, one of your colleagues, that lists her as open records custodian. And it says, "The Fulton County District Attorney is in receipt of your request. Please simplify your request." So as Mr. Franciscan, I think, all right, it looks like the office of the county attorney, that's in big letters at the top. That's who I'm communicating with, and the message is from Ms. Burwell.
Right.
And that was at 1:57, and at 2:02, so 5 minutes later, seemingly Ms. Burwell of the county attorney's office sent an email that says, "After carefully reviewing," that's an important adverb, "your request, we do not have the responsive records." So what I'm hearing you say is those two sentences, because for whatever reason, it's two sentences, "After carefully reviewing," let me share the screen. So we all are seeing the same thing. Because I just want to make sure I'm understanding it. All right, and I think I can make that a little bigger. So I am focused on that. What I'm understanding you to say is Ms. Burwell did not author those two sentences.
Correct.
They
So,
were forwarded to Mr. Franciscan because the way the system works is that the designated agency here, the district attorney's office, they put back into the portal, we don't have anything.
yeah.
And then what gets generated automatically for poor Ms. Burwell with her name on it is this is what we, the county, learned from our component.
Correct. And
Okay.
and this is one of the projects that we have either correct. I believe that this is something that we've are in the process of revising and correcting, or if we have not done so already because of this confusion. We have this letterhead. K. Burrell is not even the open records custodian anymore. So this is something that has caused a lot of confusion for the public. And this is something that I did clarify with Mr. Monroe, because initially Fulton County was named as a defendant in this action. And after further providing documentation showing from the Fulton County, so there are two views. You have the requester's view of the portal, and then you have the Fulton County's view of the portal. And from the Fulton County's view of the portal, you see clearly which member from which department, which agency provided responses to the requester. And I was able to provide that to Mr. Monroe, which then clarified who in fact received and who in fact responded. And in this case, it was verified that that was actually the DA's office who received and responded to the request, which is why Fulton County was removed from this action. But I do agree with the court in how that can be very, very confusing to the public who may not be someone who is well versed on how this works or has much experience with how this works. And that's something that the county is actively working on correcting.
Okay.
So just to remind the court of my last point in terms of our diligent search, which was represented in our most recent communication and a letter to plaintiff's counsel saying that we did a diligent search was conducted, and it yielded a result of the letter that was directed by the court to provide the December 17, 2021 letter, which was, according to the district attorney's office, leaked. That letter too was supposed to be privileged. However, that letter was leaked. They had access to it, and pursuant to the court's order, we provided that letter. We also provided that letter in our discovery responses, in the first set of discovery responses. Now we're here in terms of
the date, if you've got it, or we can dredge it up somehow, that you or someone from the county provided to Judicial Watch the assertion of, okay, now we've diligently searched, that's the phrase you just used, and we have found some responsive documents, but you can't have those. And then here's this letter that you can have, which really we don't think we should have to turn over, but we know it's been leaked. And so here is that. When did that happen?
That happened on December 9th. That was an email, a letter that was emailed to plaintiff's counsel by Dexter Bond.
Okay, so that came from Mr. Bond to Mr. Monroe.
Correct.
Okay.
And attached to that letter was the court's default order, and it as Exhibit A, and Exhibit B being the December 17, 2021 letter from the district attorney, Fani T. Willis, to Honorable Bernie G. Thompson, a chairman with the January 6th attack committee.
Okay.
So if I could just, I know counsel went over his fees in Exhibit 1. If I could just highlight some things that we did find a bit questionable in the list of fees. So obviously, fees must be earned before they could be asked for. And in this case, we do have the attendance of an attorney's fee hearing that had not been earned at that time, a drafting of a motion for special master and in-camera inspection. I had not received a copy of that. motion, nor was I notified that a motion of that nature was filed or going to be filed. We've never had that communication before. So I did call Mr. Monroe regarding that. He represented to me that he had not filed it yet and that he was going to file it. So we took
It hit
issue.
the docket, well, it's at least listed as being filed effective the 17th, so 3 days ago.
Okay, but it was billed for on the 12th. Okay. So, and also too, with fees, we must make sure that we are at the very least describing the task or the legal service or the task at hand in great detail. So we make sure that there's no duplicity or excessiveness in terms of their charging of their rate. So for example, we have here emails to client let's go back to, let's start at December 3rd, correspondence to client. The task is not detailed here. I don't know what this correspondence is concerning. We have here, moving down to May 30th, calls and emails to client. I don't know regarding what. May 29th, same thing, correspondence with client. I don't know regarding 5/21, same idea, tasks not detailed. And there's a few others here. May 10th, correspondence to client. May 6th, May 1st, correspondence to client, where we don't have a detailed understanding of what those communications involved. And then if I can just scale back up, it says here, well, we talk about the deposition. I understand when we received the default order from the court, we understood that the court made its ruling on injunctive relief in terms of the records. Then I contacted opposing counsel to say, hey, there's no need to move forward. We had already scheduled this deposition, but we said, given the court's default order, there's no need to move forward on this deposition because they weren't confident in the documents being produced pursuant to the court order. They decided to proceed with the deposition. And we had a 2-hour deposition. I'm assuming, it says here, a total of 4.5 hours. I'm assuming that included counsel's travel to the deposition. But it says here, attend deposition, 4.4 hours. The deposition was only 2 hours long. So I'm not sure if the 2.5 hours were for travel. So that would need to be clarified. All right, so we have here on 11/15/2024, review leave of absence of San Monroe of 0.3. To review my leave of absence, I don't believe that would take that long, so we do deem that to be excessive.
Took me about 4 seconds.
Right.
Taking 2 weeks off for the holidays.
Exactly. July 22nd of 2024, it says here, review Fani Willis's discovery response and discuss with Russ. I don't know who Russ is, but assuming that's his client. I do believe that's duplicative, and I'm going to tell you why. Because on July 3rd, right below that, it said reviewed Fani Willis's response. So you reviewed it twice, and then you had a discussion with your client on the second time. So when you reviewed it the first time, it was 2.5 hours, and then you reviewed it a few days later and discussed it with your client for 1.3 hours. We do believe that is not only duplicative, but excessive. And that is all I have for now for the court regarding fees.
Okay, I appreciate that.
Thank you.
Mr. Monroe, I have 2 questions about your Exhibit 1 to your affidavit. One is an entry from May 21. It's not a lot of time to build, but it says draft letter to Georgia Attorney General. Talk to me about how that's pertinent to this case.
So you're
furthering your client's interests, et cetera.
Sure. So, and this was, if you look at the date, it was back in May. I think we weren't in a default situation yet in terms of we definitely didn't have an order. I think we might have filed the motion by then, but we weren't sure what was going to what was going to happen with it. We didn't know how successful the litigation was going to be. So we also drafted a letter to the Attorney General basically complaining about the DA's office failure to abide by the Opens Record Act in case the DA's office, or in case the Attorney General wanted to take some action.
Okay. And then your response to Ms. Monroe's observation that Mr. Bond's deposition was 2 hours, not 4.5 hours. Because the entry isn't prepare for, it's attend, because you have an entry for prepare for deposition.
That's right.
I'm asking about that one, but there is this attendance 4.5 hours. And it doesn't look like a 4.5 hour length one, but I'd like your feedback.
Sure. It was actually, I think, more like a 2.5 hour deposition. I mean, obviously time on the clock is not all of it, and we took a break in the middle of it and that kind of thing. But yeah, it does include the time for me to get from my office to the county attorney's office and back again.
Okay, that's the Dawsonville commute.
That's
There
right.
and back.
That's
Okay.
right.
All right, thank you.
You're welcome.
That's all I need.
Okay, I did have a couple of comments and rebuttal.
Sure.
All right. So let's just assume for the sake of argument that the response to the default order was based on a diligent search. We're not convinced that it was, but even if you assume for the sake of argument that it was, that doesn't address what happened the first 2 or 3 times where they said they searched and didn't. I mean, they admitted they didn't search, and where they conducted another, actually the way they worded it, they conducted 2 more searches and still found no records when in fact, that was after we had filed the complaint and attached a letter that they should have recognized was responsive. They still said they didn't have anything responsive. So, I mean, they lack substantial justification, at least for the most of the time. I think it's premature for us to know what they did the 3rd time around, and that's why we're asking for the special master and the in-camera inspection. But it's patently obvious that they lack substantial justification in saying we did a search when in fact they didn't do a search. And then when they did a search and didn't even find what we had already said, hey, here's a responsive record, they didn't even find that. As far as the need for the deposition, as Ms. Monroe said, we had already scheduled it. And in retrospect, the deposition was very valuable. I mean, we got good information there that we hadn't gotten in our written discovery. So even though the deposition actually took place after the default order, I don't think there's any question but what the deposition was appropriate and useful in the case. Ms. Monroe did mention the filing, or there's an entry in here for drafting the motion for in-camera inspection and a special master. That had been drafted at the time this entry was done. We just hadn't filed it yet because we were still tweaking it. And then it charged anything extra for, the tweaking and the filing and that kind of thing. So those are my responses to that, Your Honor.
Okay, thank you. Ms. Monroe, you had stood up at one point. I don't want you to be left unheard.
I'm so sorry. Thank you so much. And I won't readdress the whole substantial justification portion. In fairness to opposing counsel, he has the final say on that matter. Just 2 things that I forgot to mention, and the court reminded me, the drafting of that letter to Georgia Attorney General, we never received a copy of that letter. So I was surprised by that entry. I had it here, but for some reason I didn't mention it. And then there was on the 3rd of March, before the action commenced, there was a conferring with a client regarding open records for 1.2 hours. Again, that was before the filing of this action, and we're asking that not be included in the fees as well.
Okay, got it. Mr. Monroe, anything else we need to cover today?
I don't know if you want to do it yet, Your Honor, but I mean, you've mentioned that the other motion is not ripe yet. We could schedule a hearing on it if you want to do that.
So I want to give the county an opportunity to respond.
Of course.
The motion is out there. They've got 30 days to respond. It sounds like part of the response may be outreach from Ms. Monroe to say, what can we do short of a special master? And I encourage you to engage with her on that. I know you will. But when it's ripe, I don't know that we need a hearing. We may have to have a hearing. I certainly need to rule on it. I suspect we'd need a hearing because of these different levels of special master intervention into the inner workings of the district attorney's office. The most intrusive to the you give me the documents that you produced, I'm gonna look through that, to decide, is it privileged or not, kind of thing. And so we probably do need to talk about that, but the county's entitled to respond in writing first.
Okay, I don't disagree with that. I was suggesting that we could schedule something far enough out that they'd have time to respond.
Okay,
As for the need for hearing, I think the rule actually requires a hearing, and the Court of Appeals has reversed on appointments of special masters if a hearing wasn't done. So
okay, well, I don't
we
want
want that
that
or
to
not, I
happen.
think we're having to have.
Okay, good, then we'll do that. But what I'm gonna do is well, I'll talk with Ms. Niles. I know my January is already with a civil trial calendar and a criminal trial calendar. But I don't want this to languish either. So we may set that down for early February, knowing that we'll get the response and you'll have a chance to digest that, and then we'll be good to go.
Okay.
Okay.
Thank you.
Ms. Monroe, anything else?
Yes, Your Honor.
Okay, well, I appreciate you all being here on a Friday. Please make sure you take care of the court reporter, whoever asked the court reporter to be here, whether you're splitting that up. I will get an order out in connection with the attorney's fees request. And maybe it'll have a little scheduling piece in it as well concerning a hearing on the special master. Appreciate it and happy holidays.
Thank you, Your Honor, same to you.
Oh, one last thing. Is Mr. Bond's deposition already in the record? Do you want me to give this to the court reporter so it's made part of the record? Was this my courtesy copy?
It's in the record, it's your courtesy copy because you have a standing order that you want hard copies of anything more than 50 pages.
I appreciate you complying with the standing order. I just, if it also needed to go on the record, I'd do that, but if it's in, we're good to go.
It's electronically filed.
Excellent. Thank you, everyone.
Thank you. Oh, yeah. Absolutely. No question about that.
Yeah.